We have the pleasure of having Mr. Frank Anderson with us this morning. And Mr. Anderson is an attorney with Anderson and Fugate, a law firm. He is admitted to practice before all courts in the state of Tennessee, including the Tennessee Supreme Court. One of the tie-ins for us, of course, in health administration is that he is a healthcare attorney. He and his firm represent Mountain States Health Alliance and have done so for 17 years. So he's got a tremendous amount of experience. If you remember, during that time, Mountain States wasn't formed. Johnson City Medical Center was a standalone facility here in Washington County in Johnson City, and then had some acquisition and some growth and mergers and all kinds of things happen. So he's had that wonderful experience over the 17 years. He is a member of the Washington County Bar Association, the Tennessee Bar Association, several other organizations, and an all-around good guy. So give him your undivided attention. You'll learn lots today.
Thank you, Brian. The obligatory clap. I just love that. I'd rather have it now than when I get through. I may not get one when I'm through. I guess I'm supposed to be over here, so I'm going to start here, and I may move around, as most lawyers do who do trial work. I don't like to stand in one place. I appreciate you having me. When Brian asked me to come, I do a bunch of speaking for healthcare groups. It may be providers. It may be, it can be doctors, nurses, frontline folks, administrators, and have done for a number of years, and I enjoy doing it. My style's pretty laid back. Just jump in there if you want to ask something, and we'll talk about it. Otherwise, it could get a little boring. And the only reason I say that is that a lot of what we're going to talk about today are things that may seem mundane and kind of, put you to sleep. But if you're in healthcare administration, management, whether it be in public administration, private, whether you're a provider in the healthcare setting, whether you're a consultant with a facility, whether you're an attorney who does healthcare work, all these things we're going to talk about are very crucial. One, to avoid substantial fines and penalties. Two, to keep your accreditation. Three, to be able to work with, care for, and bill Medicare patients. And four, probably most importantly, to keep you out of jail sometimes. So a lot of what is on here are things that you will probably see at some point in your career if you get into healthcare administration or management. And so that's kind of the topic. When Brian asked me to do this, the bulk of my speaking is directed toward litigation, risk management issues, things that you see that ultimately would end up in a courtroom setting. I've practiced for about 30 years, and the last 17 or 18, my firm has represented Mountain States, and we're their general counsel. And it has grown, and Brian kind of alluded to this, it's grown from one little hospital, Johnson City Medical Center, for those of you who are from Johnson City, to now 16 hospitals of some size, as well as a ton of physicians, healthcare providers, surgery centers, both in Tennessee and Virginia. So it is amazing what healthcare has done over the last 20 years especially. And unfortunately, my firm hasn't grown to stay up with that, so we're pretty busy as we go along. There's four of us who handle all of the Tennessee work for Mountain States. From time to time, I have to ship things out because we just get overloaded. And then I do a lot of the Virginia work also. So we've got a pretty good handle on everything in healthcare. I will tell you, when Brian asked me to do this, like a good partner in a law firm, I delegated to my associate to put this together. And so, like a good partner in a law firm, if you don't like it, it's her fault. If you really like it, I get the credit for it. So, and it was interesting because I know I have about an hour, I think, and most of my presentations will go anywhere from an hour and a half to maybe a half a day sometimes. And so I told Stephanie, I said, I've got an hour. Well, she put this program together that literally was the size of a Bible, and I said, there's no way I'm going to be able to cover that. So she basically reduce it to the New Testament, you know, about like that. So there may be things on here we have to you feel like we're rushing through, and if we do, it is probably because we're rushing through it. I want to at least touch base on a lot of these things. She actually wrote me a script out. This is a CPA background person. You know, she was a CPA, went to law school. So you know how CPAs are, they're kind of structured and a little OCD-ish. So, you know, I basically could read this script like it's a play, but that's not my style. Everything you see here we'll give you at the end of class, so don't worry about it. I may give some things out ahead of time if we talk about it, just so you'll see some forms. But with that said, let's jump in. So again, if you have any questions, just feel free to jump in there. I'll check my time, see how I'm doing. Again, I'll try to stay on pace here. Okay. The thing about healthcare, and all of you know this if you're in this program, it's not like any other industry. Things that are great business decisions for the best interest of the company in the normal business setting may not apply in healthcare. And because of and that's because that healthcare is probably, if not the most regulated industry in the United States. You have federal laws and regulations that you have to comply with. You have state laws and regulations you have to comply with. You have the Joint Commission or other accrediting agencies to be accredited that you have to comply with. You have the Center for Medicare and Medicaid Services, CMS, you have to comply with all of their conditions of participation as a hospital or a healthcare facility in order to participate in the Medicare program. So, you know, you may see as you get into your profession and you're dealing with physicians or the general public that something sounds great on paper, it makes sense using common sense, but you can't do it, unfortunately, because of these restrictions in the healthcare industry. So that's something to keep in mind. I could have gone through probably 20 different things that might have been applicable to you as someone who is going into the healthcare arena. These are some that we're going to hit on. And as I said, Stephanie broke this down like it's a law school class. So I'm not going to bore you with the intricacies of a lot of these, but we'll touch base on them. And I think it's important that someone who is going into the management side or the administration side in healthcare have some familiarity with all of these areas. And the reason being is that many times once you decide to take something serious in a particular area, the horse is out of the barn, so to speak. You can't get it back in without substantial sanctions from the government, either state or federal. So what I tell people who are going into healthcare management is have some familiarity with globally things that you might encounter, and then two, find a really good healthcare lawyer that you can call, because it is important to get someone on the front end. And in at least this part of the state, there are very few attorneys who do healthcare work. You can't just go to a divorce lawyer and have him do healthcare work. You can't go to a criminal defense lawyer. I did all those things for about 15 years and enjoyed doing it until I had the opportunity to start representing Mountain States. And one thing I found out real quick, a general practice attorney can't do healthcare work because it's so complex. You can't dabble in it. You have to almost really just make it your life and decide to specialize in healthcare work. So those are the two pieces of advice I would give you. Have some familiarity with some of these things we're going to talk about and many others, and to make sure if you're with a facility, an organization, a private setting, whatever, that you have access to a good consultant or healthcare attorney. We're going to talk about these kind of areas: advanced directives, risk management, litigation. We're going to talk about employment, labor and employment laws, which are not just unique to the healthcare setting, but seem to be more prevalent because of the demands in healthcare. The demands that you see, you get patients treated quickly, timely, properly, and out the door. And so if you have labor and employment issues with your employees, it seems to affect how the product is ultimately served to the public. EMTALA, Emergency Medical Transfer Active Labor Act is, we're going to talk about that. And then the last are some of those dreaded regulations that the federal government throws out that you will deal with. I can guarantee you if you work as in the management side or the administration side of healthcare. So we'll talk a little bit about that. Okay. Now, this is the other thing Stephanie did. I said, Stephanie, just come up with something for me to talk about for Brian's class. So what does she do? She comes up with the little scenarios, you know, she likes. So I'll come up with a little scenario, Frank, and we'll throw it out to the class. And then we can talk about it. So I said, oh, okay. Well, some of these scenarios get pretty convoluted, but here's the first one. This is talking about healthcare decisions. An ambulance brings a patient to your hospital, to your emergency room, and the patient's been in a motor vehicle accident. Patient hits the door, is unconscious, and the question is, what do you do? And these things happen every single day. And so you may ultimately at some point be over an emergency room setting as an administrator. You may be over a facility that has a dedicated emergency room. You may be in an urgent care setting. But anyway, the question is, can you treat the patient? And then after you treat the patient in the ED, you admit the patient to the hospital, inpatient, and then family members start showing up. And again, the patient is unconscious, can't make his or her own decisions. So what do you do? What kicks into play? So, with that said, what you have to do, what you need to be aware of as an administrator is that every patient has the right to make his or her own medical decisions if they're competent to do so. And they have a right to know the risks, benefits, consequences, the treatment forms, any alternative treatment, things like that. As long as the patient is competent, they get to make their own decisions, even though the healthcare provider or someone in administration who is trying to solve the issue may not agree with that decision the patient's making. So every patient has a right to informed consent. The problem becomes is if the patient is not able to make those decisions. In an emergency room setting like the little scenario that we just had, Tennessee and most every other state allow you to treat a patient in a true emergency without consent. So, you know, if the patient is unconscious, no family around at that time, healthcare providers can render treatment without permission or consent from the patient or anybody else. And so that's kind of an easy one. What happens is, and what I see all the time is, mama comes in, she's treated in the emergency room, she's admitted to the floor, and then you have children from all over the country coming in because mama's not doing well, she's unconscious. They all come in, they all want to jump in there and make healthcare decisions for mama. And some of the nastiest things I see, quite honestly, in a healthcare setting is where you have a serious patient not able to make their own decisions, and you got family members at war with each other to make those decisions for a loved one. And they all seem to have the best interests of mama at heart, but you've got the administration, you've got all the management in that unit and that department, you've got the doctors, you've got the nurses being pulled and tugged in every direction. And so, what do you do? What do you have to look for? And this is what really are the four areas that we have, at least in Tennessee, and most states have the same kind of animal. It may be called something different. But everybody's heard of the old living will. Everybody knows what a living will is. Well, a living will now is called an advanced care plan. And you still have living wills, but if you see the words advanced care plan, that's what we're talking about, is a living will. Everyone's heard of a durable power of attorney for health care, where you can appoint someone to make your decisions if you can't. Now it's called an appointment of a health care agent. And that's the same document. And what we might do is those forms on the right, I'm going to give you some forms that are these forms that we use on a daily basis and that the state of Tennessee, just so you'll have those and see what I'm talking about. But these are forms that have been developed now by the state of Tennessee. Several years ago, the legislature in Tennessee amended several of the healthcare laws and came up with what's called the Healthcare Decisions Act. And that's just a very pretty complex state law that helps hospitals, administration, management, doctors, nurses make some of these difficult decisions go a little smoother. And so what we now have are these documents: advanced care plan, healthcare power of attorney, or an appointment of a healthcare agent, something called a POST, that's a physician's order for treatment throughout the life of the patient, and then what's called a surrogate decision maker, which in my mind is probably the best law related to healthcare that's come down in the last 10 years. And I'll tell you about it in just a minute. But the forms you're seeing are standard forms. They're not unique to just Mountain States. But they're very important forms. Hospitals who participate in Medicare are required by Medicare, conditions of participation, to ask patients, adult patients who are being admitted to the hospital, do you have an advance directive? And by that, do you have a living will, or do you have a healthcare power of attorney? And then you'll hear me refer to them that way rather than the new terms. I'm still used to that's, you know what I'm talking about. And you're required to ask an adult patient that. And if they do, you're required to get a copy if possible and put it on the chart. And if they don't, then you give them an opportunity to complete one of those documents on admission. And the reason being is it makes the life of everybody in a hospital setting or a healthcare facility setting so much easier because of the disputes that we're just talking about with family members coming in, patient unable to make their own decisions. And so the forms you're seeing allow you to do certain things that will assist in the treatment of the patient who's unable to do so. So if you look at, let's look at the advanced care plan, or what I still call the living will. Basically, it kicks in if a patient is unable to make their own decisions. That's up to a physician. Now, if you have a permanent or a temporary unconscious patient, someone in a coma, then that's obvious. But if you have a patient who is able to communicate somewhat, but unable to, in the mind of the physician, be competent to make his or her own decisions, some of these documents will kick in. With an advanced care plan, you have basically certain conditions or categories of life that, if present, will allow the document to kick in. And we'll talk about that in just a minute. But basically, if you have what I call the old durable power of attorney for health care, where you appoint your spouse to make decisions if you can't. Those also set out what the agent, the healthcare agent, can do or not do. One thing that we get a lot of times on the administration side in a hospital is you've got a patient who's got a living will. Patient's probably not going to survive an accident or an illness. The patient also has a durable power of attorney for health care. Appointment of healthcare agent. So you've got two documents, which is pretty standard for a patient to have both of those. Well, it's obvious the patient is, condition is irreversible, but you've got the agent who might be a spouse, might be a child, who is wanting you to keep trying and trying and trying every heroic measure to keep his or her loved one alive. That becomes a real dilemma for those involved not only in the care of the patient, but those administering or managing a facility where that's occurring, because you have ramifications. You know, the agent is saying, I'm going to sue everybody, I'm going to sue the hospital, I'm going to sue you, I'm going to sue the doctor, I'm going to sue the nurses if you don't do what I say. You've got a physician saying, it doesn't make a difference. You know, we're doing things that aren't necessary, aren't going to be effective, they're futile. So it's very clear under the law that an agent, someone who holds that power of attorney for health care, cannot override the wishes of the patient. So truly, if the advanced care plan or the living will has kicked in because of the conditions present, then you have to honor that, even though the agent who's holding this power of attorney says, no, you're not going to honor it. I want you to do this. And so you see that a lot come up. And that's a pretty difficult conversation to have with a son or a daughter or a spouse, saying, I don't care what you say. I mean, obviously you don't say it that way, but that's the gist of it. You know, I'm sorry you feel that way. We're not going to be able to honor your request because your mother has said, if this is present, I don't want any heroic measures. I don't want any CPR. I don't want any life support. I don't want any artificial hydration or nutrition. And so that becomes a very difficult situation. Many times administrators in hospitals or healthcare facilities sit on ethics committees too. And that's what you get to deal with. And that's not a pleasant topic to deal with, but that's something that just happens, unfortunately, in the healthcare setting every day. So those forms that you have there are just examples of forms that we use. These are the categories of conditions of a patient that are, if present, allow a living will or what's called an advanced care plan to kick in. There is one huge typo at the first one where it says unconscious condition. Left out one little word that's pretty important, permanent. Okay, permanent unconscious condition. And the reason being is obviously someone can be in a coma and come out of the coma. This is where a permanent unconscious condition, a permanent state of confusion, someone who can't do their activities of daily living for themselves. They're unable because of the deterioration of their body through a lengthy illness has put them basically in a condition they can't care for themselves anymore. And then end-stage illness is someone who's on the last or the end stages of a very serious terminal illness. If any of those are present, then the living will or the advanced care plan you fill out allows you to do any or none of the above. And what you'll normally see is no CPR, no life support, no treatment of any new conditions. Many times you'll see a patient desire to have artificial hydration and nutrition pending the outcome of their life. But so they have a right to make that decision, I guess is where I'm going with all this. And this is something that you will deal with. You're not the one treating the patient, but I can assure you, you get those calls. You know, I get a call at 2 and 3 in the morning, it seems like every other week, about some condition where we've got family members. You've got 3 sons, one from California, one from New York, and one from Johnson City, who have all congregated, you know, for their parent. And you know, they haven't seen, 2 of the 3 haven't seen their parent in 15 years, but suddenly they want to make all the decisions. And the one in Johnson City, who's cared for the parent for the last 10 years, you know, as the parent's condition has deteriorated, has no more authority unless there is a power of attorney for health care that's pointed him to do it than the other brothers who haven't seen mom in 15 years. So it becomes a very difficult situation. As I said, that led into what's called a surrogate, a medical surrogate. And as I said, I love this law. And the reason I love this law, it makes the life of everybody in the hospital or the healthcare facility just so much better when you have to deal with the situation we've talked about. And what this law basically says is if you don't have a living will patient, you don't have a healthcare power of attorney, whatever we're calling it now, if you don't have that, then the physician can designate a medical surrogate for the patient. And that medical surrogate basically steps into the shoes of the patient and can make medical decisions, even though he or she was not appointed on the front end. And so you can actually do that yourself. If you go into the hospital, you don't want to do one of these documents that you're asked about on admission, but you say, yes, I want to appoint so-and-so to be my medical surrogate. The doctor will write an order to that. There'll be a form filled out, and that will be your medical surrogate for purposes of that admission only. But the reason this is so important is the scenario I just gave you, the 3 sons show up, there's no living will, there's no healthcare power of attorney. They're fighting over one wants heroic measures, the other two don't. What used to happen is we would have to go to court, basically, and get the judge to appoint one of those children to make those decisions. It was costly, it was timely, I mean, it was time consuming, a lot of heartache, a lot of hostility, a lot of emotion, and so it just wasn't a good thing to do. So the legislature, when they came out and amended the Healthcare Act in Tennessee, and most states have this, but when they amended it, they provided for this animal called a medical surrogate. And basically what it says is you physician, if the patient can't, appoint someone. And basically the law in Tennessee at least gives an order that you can look at of descending preference. The spouse is normally the one they will appoint, assuming that they're not legally separated. The law says if they're legally separated but not divorced, you can appoint the spouse. And then it goes on down, adult child, parent, brother, sister, things like that. But it goes all the way down and it says if none of these are present, then you can appoint any other person who's exhibited a love and concern and care for that patient. It might be their best friend who's their next door neighbor. It might be someone from their church. They may not be related. So the physician can appoint that person. And then, if they're not around, technically the physician ultimately can appoint himself under certain circumstances if no one else is around. We see that, you know, there's just somebody comes in, no family, no friends. What do you do? By law, these are people who cannot serve as surrogates. The doctor, the treating doctor, except when you go all the way down, as I said. I'm not going to bore you with all the details, but basically anybody who's an employee of the hospital or the facility where the patient is, the operator, that means management, and then any employee of the doctor and any employee of the healthcare, unless they're related to the patient, okay, which makes sense. The last thing I'll mention on this, the law has also said, you know, I told you about threatening lawsuits. Happens all the time. You know, if you don't keep mom on life support, I'm going to sue everybody. Well, you know, if decisions are made in good faith by the surrogate, by the doctor, by the one who is the healthcare agent, then Tennessee at least provides immunity from civil damages. So they may sue you, but they can't collect anything. Okay, you're immune from having to pay any monetary judgment if you did everything in good faith. Okay. Okay. The only thing I did on that is spend more time than I wanted to. Any questions? You all are being way too quiet, and that's okay. Okay, let's talk about risk management, which is kind of my cup of tea. And here's another little scenario we have. Elderly patient's son calls the secretary of the administrator of the hospital saying his mother failed to get her Coumadin, her blood thinner, for several days while she was in the hospital. After she was discharged, his mother suffers a stroke at home 2 days later, and he's blaming the hospital, saying that the fact she didn't get her Coumadin on a regular basis is the reason she had the stroke. So you, as someone who's in management of an organization, a healthcare organization, a healthcare facility, would love to investigate that. The problem is that you're concerned that your investigation, statements you get from people, records, will ultimately be turned over to the patient or his or her attorney when they sue you. And so, you know, you have this real conflict of interest. Gee, how can I get this information and it not be discovered later and be damaging? Because when you go talk to a nurse or a physician about what happened, they're less likely to be honest and talk freely if they know whatever they say to you is going to be turned over to the patient's attorney a year later. So there's this freezing effect on trying to do a good investigation. On the other hand, you as someone involved in management want to make sure if that occurred that steps are taken, it doesn't happen again in the future to another patient. Tennessee has developed an act, used to be called the Peer Review Law. Now it's called the Patient Safety and Quality Improvement Act. And all it says is that if you're a healthcare organization and you meet certain requirements and you have what's called a Quality Improvement Committee, that committee, if done correctly, can investigate all of these things, and everything they investigate is protected and privileged and not subject to being gotten later by the other side. Okay? And it's something that we use every day because, as you well know, every single day there's either my client may not like me saying this, there's either an incident or a near miss in a hospital, right? I mean, it's not unique to Mountain States, but may not have a client tomorrow, but anyway, you understand what I'm saying. You know, every single day. There may not be an incident, but it may be a near miss. And we have to investigate those near misses, because those near misses we don't want to turn into actual incidents later. So you try to improve the process, improve what's going on. And this is how you do it, through the Quality Improvement Committee. It protects everything. It allows you to investigate physicians who are on your staff, who work for you, if you're in an organization that employs physicians. And you can gather information, and the person you're getting information from can feel confident that what they're telling you will not be disclosed to the attorney for the physician if he sues for losing his job. So it's a great animal to have. It's a fantastic law. Most states have this kind of thing. Tennessee probably has a more liberal law along these lines than a lot of states do. So it's very important you structure your facility or your organization if you don't have that in a way that allows you to use this. In addition to the state law, there are two federal laws that do very similar things. They're not quite as comprehensive, but the Federal Healthcare Quality Improvement Act is a federal law that's been around a long time that says, in essence, the same thing, that information provided to a peer review or quality committee is protected, and that the hospital, the administrators, the board of directors, et cetera, who sit on these committees and in these organizations that have these committees are immune from damages if sued. Something that comes out of that committee in case it adversely affects a physician, for instance. And then also the Federal Patient Safety Act is similar to this, as it's a federal act. Okay. Okay. As I said, things I'm talking to you today about are pretty unique to the healthcare arena. This one probably isn't, but it seems like it is. I do a lot of labor and employment law, and I talk to a lot of colleagues around the country who do it, who represent corporations and organizations who aren't healthcare entities. And there are some very unique things that you have to deal with in the healthcare industry with employment issues that you don't in a manufacturing company or another industry. So I wanted to put this in here for that reason. And so our little law school scenario, let's see, is you got three people who are working at the hospital, and you have a nurse who works on the medical surgical unit, and she's pregnant. And she's having problems, and so her doctor says she has to go on bed rest the last 3 weeks. Okay, well, that's okay, you know, understandable, we can cover her absence. Unfortunately for you as the administrator, or maybe the department director on the floor, her husband works for the hospital too, and he's in biomedical engineering, and he is crucial to getting this equipment up and running so that you can open up this new unit in the hospital. Yet he wants to take time off to be with his wife during these 3 weeks, and also time off to care for their child. And then if that's not enough, you got mom who works in admitting, okay? So she's in admitting. So you have 3 family members working at the hospital. And mom wants to take time off and be with her daughter, and also to take time off when the child's born. So they all come to you and they say, we want leave. And you, as our employer, have to give us leave under state and federal laws. and you scratch your head and you say, ooh, I'm in trouble because if I lose husband for a long time, you know, we're not going to be able to open up that unit. If I lose nurse for a long time, you know, she's a crucial nurse on that unit, we're short-staffed anyway, what do I do? And then admissions, of course, is very busy from day to day. So what do you do? So we talk about generally, let's see, wait a minute, let me back this up. There we go. Did I have that up already? Mm-hmm. Oh, okay, double clicked. There are 4 laws that you would have to have some familiarity with to know that they could kick in a scenario like we just talked about. One's a Family Medical Leave, that's FMLA. Most people have heard of that. That's a federal leave law. The Tennessee Maternity Paternity Leave Act is a state law in Tennessee. And then the last 2, the ADA, which we've all heard of, and the Pregnancy Discrimination Act are both federal laws. They're not leave laws, but they're anti-discrimination laws. So every one of these can come into play on the scenario that we just talked about. So I guess I've done that one already. Maybe I'm going the wrong way. Let me try that. There we go. Okay. FMLA is basically a federal leave law. It says that anyone who has a business, any employer that employs 50 or more people, have certain requirements under labor and employment laws. And that is that you have to allow leave for certain conditions if the employee meets that. And at least with the FMLA, and what you'll see as we talk about this for just a minute, they all kind of intertwine. So I wish it was just simple. Gosh, you know, you meet this one, you have to worry about the other 3. If, you know, that's not the way it works, unfortunately. But anyway, this says that each employee who works for someone that employs 50 or more people is entitled to 12 weeks of year of unpaid but job protected leave. That means they don't get paid while they're off, but their job's protected while they're gone. Their benefits are protected. You can't cancel their insurance because they're on leave. And to be eligible, they have to have worked 12 months with you, with that employer, and have worked 1,250 work hours. And when you put a pencil to that, which I did yesterday, I was just curious, 24 something hours a week. Okay, so you roughly, if you're averaging 24 or 25 hours a week and your employer employs 50 or more, you're going to be under the FMLA. Okay, it allows any employee to take leave for those conditions right there: child care following the birth or adoption of a child, to care for a spouse, a child, or a parent with a serious health condition. That's the key term. And then for the employee's own serious health condition. Now, pregnancy in and of itself is not recognized as a serious health condition. Okay, so under FMLA, if you have a normal pregnancy without any complications, it would not be considered a serious health condition. However, in our little scenario that Stephanie did for me, the woman's developed some complications. So, who's eligible under FMLA? Pregnant employee would be, she'd be entitled to FMLA leave for the 3 weeks because she's developed probably what would be considered a serious health condition. The way that's defined roughly is you're either required to be admitted to the hospital or you're requiring continual treatment by a physician. So in her case, probably the latter. So she would be eligible. She's also eligible for, as you see, child care following the birth. So she's eligible under that situation. So she gets 12 weeks of leave. If she uses 3 before the birth, she's got 9 left, if I did my math right. The spouse and the father, he would be entitled to that most likely. And I don't mean to keep switching back and forth, but basically he would be entitled to it because to care for a spouse with a serious health condition, he meets that. And also, he would be entitled to more for the child care, to bond with his child. And then mom would not be entitled most likely unless she falls under the care for a child with a serious health condition. But unfortunately, the FMLA says that if the child is 18 or over, it doesn't, you don't get that benefit unless the child can't take care of themselves. So if mom is totally cannot take care of herself at all, maybe grandma could argue that she can do that. She doesn't get her, the mother of the pregnant employee does not get for child care off to bond, because grandparents unfortunately don't get that unless they have custody of the grandchild or the primary custodian. So we see that situation. So that's not too complicated. They get that. The other thing that's interesting about the FMLA is you may say, gee, so that's husband and wife, they both get 12 weeks, that's 24 weeks. You know, I'm in big trouble trying to get my unit up and running. And if they are married, they get a total of 12 weeks. They don't both get the 12 weeks, okay? And there's little offshoots of that, but basically that's what it is, okay? Okay, this is a leave act that's designed to provide leave for employees. As you can see, if you're an employer, now you got to have 100 or more employees. So if you got 75, you wouldn't be covered by this act. You wouldn't be, it wouldn't apply to you, okay? So if you're representing an employer, like many of us do, you try to keep them under 50, you know, but then you'll see another law says 15, so you try to keep them under 15 employees. And then it's real easy, you know, it doesn't apply to you. But it's hard to do if you're representing a big employer. So anyway, you got 100 or more employees. They get 4 weeks of job protected leave. So they, 4 months, excuse me, 16 weeks. So they really get 4 extra weeks under this. They don't get the, but they're cumulative, they're concurrent. So if you're taking 16 weeks under this, you've used your 12 up under FMLA, okay? You have to be employed full-time for 12 consecutive months, and there's the basis for granting leave: adoption, pregnancy, childbirth, and nursing. And the interesting thing about this is you have to give notice if you're going to take it. The law says 3 months notice, but they excuse that if there's an emergency that prevents it, or if you're, say, you're adopting a child and you find out less than 3 months that you're going to be adopting a child, then you just give notice when you find out. They excuse the 3 months. So, again, you can pay, an employer can pay under this Leave Act, they can pay employees for the leave if they're gracious enough to do that. But you can't pick and choose. You can't pick one, say, okay, I'm going to pay her, I'm not going to pay him for taking time off, because you'll run into discrimination claims. So you have to treat everybody across the board the same. But you are protected in your leave. Now, the only thing I would tell you is, I absolutely just got to figure out which way to go with this. Okay. Okay. All right. I'm going to stop there a minute. And here's the others we'll get into in a minute. Basically, I'll tell you what I want to do. I want to go back to this just a minute. Okay, so who's eligible? Obviously, the pregnant employee is, the spouse father is, to care for childbirth, for bonding. The pregnant employee's mother would not be, okay? The interesting thing about this particular law is that it's an episode law, which means it's not per year. You get your 16 weeks per episode, okay? So if you want to take your 16 weeks, you can, but if you take 8 weeks and come back to work, you don't get 8 more later, okay? And the other interesting thing about it is since it's per episode, I guess theoretically a father could get 2 or 3 of these a year. Of course, he may not be alive after the first one, you know, when mama finds out about somebody else being pregnant. But theoretically, you know, if daddy is adventuresome, he may get 2 or 3 leaves a year, you know. And the other interesting thing about this is it's unlike the FMLA, both father and mother get their 16 weeks. So theoretically, you're sitting there with the headache of having 2 key employees gone for 32 weeks if they choose to take their full allotment. Okay, ADA is the third labor law that you need to be aware of. I don't want to spend a lot of time with it, but I will tell you that as someone in management or administration in a healthcare facility, this will be one that will drive you crazy. And the reason being is that now it seems like anybody who is excused from their job files an ADA claim. The Obama administration has funneled tons of money over the last year for enforcement officers and investigators on discrimination claims. And when I had read that, I said, you know, what does that mean? Well, I'm seeing it. I'm getting tons of these claims every day, it seems like, and we have to answer. I'm getting them in Virginia, I'm getting them in Tennessee, and so you're seeing this being done. Now, fortunately, 99 out of 100 are being dismissed, but you still, it involves a lot of time on the part of management, because the ADA, which is enforced, you have to go through the Equal Employment Opportunity Commission. So the EEOC asks for just a ton of information on everyone. You know, how many people have been terminated by your organization during the last year? Well, if you're Mountain States and you've got 9,000 employees, gee, I'm not sure. Well, fortunately, you know, since they keep good records through the electronic age, they're able to shoot me that out. But, you know, how many were terminated for absenteeism? And I need their names, addresses, et cetera, et cetera. So all of that has to be funneled, and that has to be done by management. You know, management has to give it to me. So ADA means basically that you are prohibited as an employer from discriminating against an employee based on disability. There's different titles, there's different sections of the ADA. Title I deals with employment. And basically you can see the cutoff here is 15. So again, you know, keep under 15, you're good to go. If not, you have to worry about the ADA as an employer. And it says you cannot discriminate against anyone with a disability. Disability is defined basically as a physical or mental impairment that substantially limits a major life activity. And major life activity used to just be a few things. 2 years ago, the federal government came in and amended the ADA, and now a major life activity is almost anything you can think of. You know, if you get up in the morning and walk to the bathroom, that's a major life activity. So it almost covers anything. So by virtue of that, where we who used to defend these cases got out of a lot of them saying, gee, they don't meet the definition of a disability, now we almost have to concede that most times, and our defense is, but we didn't discriminate because of it. We accommodated them. So that's another one you have to deal with. The last one I want to mention real quick is the Pregnancy Discrimination Act. That's another anti-discrimination law that's federal. It mirrors a lot of the others we've talked about. But basically, again, 15 or more employees, and the employer has to comply. And it basically says you can't discriminate against an employee due to medical-related conditions based on pregnancy. In other words, if you have policies about medical conditions and how you treat your employees, you have to treat those who are pregnant the same way. They're considered the same. You can't discriminate in the hiring, in the leave, on insurance, fringe benefits. The last one's retaliation. If someone complains to you that you're discriminating against someone else based on pregnancy, and you terminate that person complaining, there's a retaliation lawsuit waiting to happen there. Okay. Alrighty. EMTALA. Has anybody not heard of EMTALA in here? I guess if you're in the healthcare setting, you've heard of it. Basically, it is a federal law that was enacted probably 25 years ago. And the purpose of it was, and is, the purpose of it was at the time to prevent private hospitals from patient dumping to public hospitals of patients who were uninsured or indigent. And so basically, to get these, what happened 25 years ago, you would see situations where these private for-profit hospitals would have patients come into their ED, and they would miraculously send them to a charity hospital, a public hospital. And obviously public hospitals didn't appreciate that. The federal government didn't appreciate that. So they came up with EMTALA, which is this federal law that says, in essence, you can't do that. And so here's our first scenario. You're working in a small rural hospital with obstetric services. Ambulance brings a woman in unnoticed or without any notice to you, who's in labor, to your ED. And the ED physician runs out and says, no, we don't deliver babies here, and directs the ambulance driver down to the next town where the ambulance, or the hospital is, excuse me. So did you violate EMTALA? And basically EMTALA says that if someone shows up on your property and you are a hospital who participates in Medicare, which most hospitals do, and you have a dedicated emergency department, which not all, but most hospitals do, good-sized hospitals, then you are required to take that patient and at least screen them medically and to treat them until they're stable or the condition has resolved, or transfer them to another facility, and there's very detailed requirements how you can transfer. And if you don't do that, then, as I'll show you in a moment, some very hefty fines. So under the scenario we talked about, you can't merely, a doctor can't come out and say, nope, send them down, you know. Can't do that if you have the capability to treat. And what happens a lot of times, and this will be the bane of your existence too as an administrator, what happens is it's the hospital's responsibility to accept patients and to comply with EMTALA, but normally they'll delegate to the ED doc or the on-call physician. So you will get a call to the ED at 2 in the morning and they need an orthopedic, there's been an accident, a motor vehicle accident, they're bringing a patient in and they want to bring the patient to your emergency department. So they call you as the orthopedic doctor at 2 in the morning saying, we need an orthopedist in here right away, you know, and you've had a tough night, you just don't want to come in, so you say no, send them on down to Kingsport, to Holston Valley. Holston Valley will not appreciate that, okay? And so what happens is the hospital gets nailed, the doctor will get nailed, and so by delegating that to a physician, you're putting yourself as a hospital or healthcare organization at risk, as I'll show you the fines in a minute. So here's the other one. The other part of EMTALA is not just people showing up on the property. The thing about EMTALA is it's really, when we say showing up on the property, we mean showing up on the property. So if someone comes to the parking lot but doesn't make it in, and they're turned away, we actually had a situation years ago. I won't tell you which hospital it was. We had a little guard who would stand out in the parking lot at the emergency department. And when someone would come in late at night and it didn't appear to him, being the medical expert he was, that the patient should be treated, he would just say, you all need to go on down the north side. You know, we're pretty busy here. And they would turn and drive to the north side, you know, when they were showing up to go to the emergency room at this facility. And so that got back to me and others, and through a patient complaint. And that is an EMTALA violation because they have showed up on the property even though they haven't gone into the facility. So we had an obligation to bring the patient in, to screen the patient, to see if there's a true emergency medical condition. If there's not, then you send them on their way. If there is, then we had to stabilize and treat the patient before sending the patient home or transferring. So anyway, you can get in some EMTALA problems real quick. So with orthopedic, the other part of EMTALA is accepting a transfer. So what you see with the Mountain States, who has a very high level of care at JCMC, the Level 1 Trauma Center, 24-hour coverage, neurosurgery, trauma, things like that. You will have rural hospitals around the region, and it could be in Kentucky, it could be in Virginia, Southwest Virginia, wherever. And they will call and say, we've got a patient, such and such, a neurosurgery patient. We need to transfer the patient over. So EMTALA says, you as the receiving hospital, if you have the capacity, if you have bedroom, and you have the capability, because you're a higher level of care, you have to accept that patient. You can't tell the sending hospital, no, you know, you got a Holston Valley's closer than we are, you know, that you're on your way to Holston Valley coming here, so send them to Holston Valley. You have to accept. So that's where you have to be careful when you're in management and administration of delegating those calls, which we all would do, to the orthopedic surgeon who is called, you know, here from the receiving hospital. Make sure they understand. By sending that patient somewhere else, They are not putting just themselves at risk, but you as the facility. So under our scenario here, you know, the orthopedic says there's a hospital closer to you than that, send them there. And EMTALA says you can't do that. Okay, you can't do that. The only exceptions are that if you don't have capacity or the capability to treat, then you don't have to accept the transfer. And then the other scenario is if truly the patient doesn't need higher level of care than what he or she can get at the sending hospital, you don't have to accept. And we'll see that. It may be someone suffered a broken arm, but it's not something that's requiring surgery or emergency surgery. You know, this hospital is just wanting to send the patient on because their orthopedic don't want to come in at midnight. So to set the break. So you don't have to accept a transfer if the sending hospital has the same capability to treat as the receiving hospital. Real quick, that is the fines that you can see that are hefty. That is $50,000 per violation for hospitals, $25,000 if your hospital, a smaller hospital, less than 100 beds. The big one, which is basically the death sentence, exclusion from Medicare. Okay, hospitals will not survive if they can't participate in Medicare in most places in the country. So one of the punishments is that you get really nervous when somebody screams EMTALA violation. You know, $50,000 is a lot of money, but it doesn't come close to sniffing what happens if you lose on the second bullet point and you're excluded from Medicare. And then against hospitals, the patient can sue you for that violation. And then the other hospital who wanted to send the patient there but you wouldn't take can file a lawsuit. Doctors get nailed too. Doctors don't seem to understand that they also have a violation.
Is the exclusion for a specific time period?
It is forever unless you can get it back. And there are mechanisms to get it back. But no, it is a death sentence. And now, you know, Mountain States has had some allegations, and every hospital will have an allegation because you'll have a doctor who, like I say, will say, nah, you know, take them over there. And so next thing you know, your risk manager is calling you and going into the CEO's office and saying, gee, we got an EMTALA violation against us. And so we've never come close to that. I mean, you know, Medicare understands if Johnson City Medical Center closed its doors, what it would do to the community. So you've got some leverage, but that is a huge, huge bullet point and a huge leverage and a huge thing you have to try to get through. So, you know, it's pretty scary. So that's why you have to take it. Okay, I've got about 6 minutes, and that's good because the part I'm going to talk about now is what Stephanie and my other associate Robin, deal with every day. These are transactional things. These are Stark and anti-kickback, and you know they're very, very, very important to the administration of a healthcare organization, but they're also to me very, 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 very boring. So, you know, and that's why I dump them on them, and they're very good at it. I don't call it dumping on them, patient dumping. I call this, you know, topic dumping, but you know. They're fantastic in this area. I mean, they get calls from all over the country. They're really good. So she wrote this up for me, and way too much info for me. You know, I read it, and I read it last night, Brian. I looked at it, and I went, well, I can go in and read my script, or I can just go in and fess up that I really don't know what the hell this is all about. But you know, I do understand this because before I hired them, I had to deal with this. But since I hired them, Stephanie's been with me 8 years and Robin's been with me 5 or 6. I have turned all this over to them. But this is a nightmare because of the regulatory hoops. These are perfect examples of what I tell you, how healthcare is different than other industries. Because here's the example. I won't read it. Basically, you've got 2 neurosurgery groups in town, and they both are losing a neurosurgeon. And JCMC is a level 1 trauma center, which means they've got to have neurosurgery cover 24/7. And with only 2 neurosurgeons left now, that's hard to do. You don't get neurosurgeons to cover every other night forever. So both groups come and they want help from the hospital. We need another neurosurgeon. Can you financially help us? And the hospital knows they need to do that in order to maintain their level 1 trauma status. So these three laws kick in: Stark, anti-kickback, and civil monetary penalties law. I won't talk about the last one. That's just where you're fined by the government under certain arrangements that are improper. But the first two I want to mention briefly, if I could. Stark is a federal law that was enacted many years ago. Pete Stark, who was a congressman at the time, was the one responsible for getting this law through. That's why it's called the Stark law. And then the anti-kickback statute is the other one. Stark is basically a self-referral law, and what it says is doctors cannot refer a patient to a healthcare organization for certain services. That means designated health services, and there's a whole list I'll show you in just a second. It's almost anything. So you can't send a patient to JCMC for radiology test or lab test if those services will be paid by Medicare or Medicaid or some federal program. And finally, here's the key: if the doctor has a financial relationship with the entity he's sending it to. And the motive behind the law is basically it would overutilize medical services. It's a conflict of interest for me as a doctor to send this patient for tests to a hospital that I may own a part of, or they pay me a compensation arrangement for something, because the thought being, gee, you know, I'm benefiting by sending them there, and that patient may not need those services. And so that question mark comes up. And so it's a self-referral law, and it is a civil law. And there is a whole list of the designated health services, and you can see almost anything you can think of is on there. Those are things that you cannot order as a physician. And this is important. If you turn out being a practice administrator at a physician group, let's say, which is becoming more and more prevalent, that is important too, to know these things, because you as the physician, by violating this, it's not just the hospital, and I'll show you in a moment. So you need to understand that your docs can't do these things unless there's certain, all the I's are dotted and the T's crossed. But there's an example of all of them. And then here's penalties. Your claim's denied, so if you have a $50,000 claim for 4 days of hospitalization, that gets denied. You don't get paid. You have to refund anything you got. Then there's penalties, $15,000 for each test ordered. So if you send somebody to the hospital and they have 4 or 5 lab tests, a CT, MRI later, et cetera, $15,000 per. Then any arrangement you have that they determine to be a scheme or an arrangement, they can fine you $100,000. And then if that happened 2 years ago and you didn't self-report it, you pay $10,000 per day penalty. So, you know, you can see the huge amount of fines. And then last but not least, potentially exclusion from the Medicare program. Okay? The thing that's scary about Stark is it's what's called a strict liability law. That means it doesn't matter if the intent was proper, if there wasn't bad motive on the doctor's part of the hospital. They just didn't do how they were supposed to do with lining up the arrangement. You get hit for all these. You can scream all you want, gee, we didn't think about it, we didn't know about it. Too bad, okay? And so those are the things there. What is a financial relationship? There's basically, let me see if I got that there. I won't make you all dizzy, but anyway, there's ownership in the facility, there's compensation. And so on our little scenario, the fact that groups are wanting the hospital to pay some recruitment money, that's a financial relationship. So if those two neurosurgeons come on board and they start sending patients to the hospital who finance their recruitment, that's a violation of Stark unless you come in one of these exceptions. And I'm not going to go through all that, it's in my notes, but basically there's several exceptions. I'll tell you one quick funny story is one of the things you can't do under Stark or anti-kickback is have, well, let me hold that a minute, I'll tell you about anti-kickback in a minute. But so that's the rest of Stark. The last thing I want to mention real quick to try to wrap up is anti-kickback. If you read about healthcare administrators getting put in federal prison for healthcare fraud, it's usually because of violation of some part of the anti-kickback law. It is basically a law that's criminal, as opposed to Stark was civil, all these monetary penalties. This one will put you in jail, okay, federal prison. And this is basically says that you can't take kickbacks. You can't knowingly and willfully offer to pay or solicit or receive anything of value in exchange for the purchase of any service or item that's covered by Medicare. So, you know, the old kickback is what it is in the healthcare program. And there are some exceptions. And so an example would be if you are running a practice group for a physician and you go to the hospital and you say, gee, you know, we'd like to have a suite in your medical office building. And they say, okay, well, the rent's $10,000 a month, you know, our normal rent. And they say, and you say, well, if you give it to me for $5,000, of course, I'm going to send all my patients to you. That's a no-no. You're receiving something of value below fair market value in return for sending patients. Federal health care programs that pay these bills don't want you doing that. So that is a crime. That will get you. You can pick up the paper every day and find some healthcare administrator or manager who's going to prison for healthcare fraud, or a doctor who's going to prison for healthcare fraud. And so practitioner recruitment is an exception, is a safe harbor that you can do, but you have to structure the deal. All the things, and I've set out, here's an example how you do it. You got to have a written agreement, set all these things out. So a lot of these arrangements can be done. You can recruit physicians, but you have to have detailed agreements that meet anti-kickback. And a real quick story, and I'll quit, but we had St. Jude's. For those who are familiar with Johnson City Medical Center, St. Jude's came in and put a satellite facility in Johnson City Medical Center, and this has been several years ago, which was a real coup to you know, the community. So families who have children who needed to go to St. Jude's now don't have to go as often. They can come to Johnson City if they're in the area and be treated here at least part of the time rather than traveling to Memphis. And so this is before I got Stephanie and Robin on board, you know, to do all this kind of stuff. And so St. Jude's, you know, the administration comes to us and says, gee, we've got this great, St. Jude's going to affiliate with us. We're going to put St. Jude's in here. And I said, great. So I started going through all this. Well, then I find out, unbeknownst to me, that St. Jude's waives all copays and deductibles for patients, so, which is fantastic. And so, you know, patients who are treated at St. Jude's, what their insurance do not pay, they don't pay what co-pays and deductibles. Well, anti-kickback says you can't have routine waivers of co-pays. That's a violation because that motivates people to come to your facility when they might go somewhere else merely because you're advertising you don't have to pay co-pays if you come to our hospital. And so that became a real issue. So to make a long story short, I said we can't do it. We just can't do it. We can't do it affiliated with Johnson City Medical Center. It ended up going, so we had this lawyer for St. Jude says we've got to do it. We want to establish a place here. We had to get, at the time, Ted Kennedy, who was in the Senate, we had to get him involved to pass a law in order to get this done. And so it basically made an arrangement that allowed St. Jude's, not only at their facility in Memphis, but at any ancillary satellite facilities, to allow co-pays, and it said that hospitals who affiliate aren't in violation of the anti-kickback law. So I was so proud of myself. You know, I'd gone and worked on this. I didn't know really what I was doing, but I worked through it. And the lawyer for St. Jude says to me, that was the first time that anybody had raised that with them across the country. Now, they were fairly new in doing this, but they'd had a few. And so the guy, one of my partners who's now in administration at Mountain States, Tim Bilal, we kind of looked at each other and went, wow, you know, we stumbled on that one. But they knew they were going to have to deal with that at some point in the future, and they were so glad we were able to get it done. So they said, what can we do to show our appreciation? And I said, all I want is an autographed picture of Marlo Thomas. And we kind of laughed about it, you know. And so, yeah, okay, yeah, right. You know, so about a month later, I get in the mail this autographed picture from Marlo Thomas. Best wishes, thanks for your help, Frank. Well, I put it in my office, you know, and it's like 8 by 11. I put it in my office, you know, and my wife comes in one day, Margaret comes in and sees it. And she goes, gee, that's interesting. It's like 2 weeks later, I get one with my wife. She'd gone and got her. Best wishes, Frank. Thanks for everything, Margaret, my wife. and she makes my staff put it right beside Marlo Thomas. But I have an autographed picture of Marlo Thomas because I stumbled onto the anti-kickback statute and knew how to handle it. You can see there's the violations right there. It's huge, et cetera, et cetera, et cetera. I'm sorry I ran out of time. Stephanie did a little video. We won't show that. But any questions, comments? Okay, thank you all.